Hello, I'm Patrick Miyake, and I provide legal advice that helps public agencies in California achieve their policy and business objectives by figuring out a way to say yes to their questions. Every month, I will answer a legal question relating to governmental agencies. Now, on to this month's question.
Pat, I've been hearing about a recent significant Public Records Act decision regarding the use of personal smartphones and computers. Can you tell me about this case?
Sure. The decision you are referring to is the City of San Jose versus Superior Court of Santa Clara County. It was issued by the California Court of Appeal on March 27th. In short, the court held that the California Public Records Act does not require the disclosure of communications between public officials using exclusively private devices, such as smartphones, or accounts, like Gmail accounts, that are inaccessible to the government agency. The court's decision was based on the specific definition of public records in the Public Records Act, specifically Government Code Section 6252E, which includes any writing containing information relating to the conduct of the public's business prepared, owned, used, or retained by any state or local agency. The court determined that records prepared, used, owned, or retained by any state or local agency does not mean records of individuals or representatives of the agency that are not on the agency's devices or accounts. The court's holding mentions a few factors, including that the individual official is not the agency and an official alone cannot act for or on behalf of the agency, that the agency did not have access to the individual's exclusively private device or account, and that there is a need to balance the privacy interests of the official in non-agency related communications. The court recognized the potential implications of its decision, that official, agency-related communications can be shielded from disclosure by being done through exclusively private devices and accounts that the agency does not have access to. The court said that this is an issue for lawmakers to address through legislation. Note, however, that the decision only pertains to Public Records Act requests. It does not apply to discovery and litigation. My own reaction to this decision is that it goes against the trend that has been occurring over the last decade of requiring greater access to correspondence between public officials. And I would not be surprised if this decision is appealed or if it results in legislation that amends the Public Records Act to make agency-related correspondence on private devices or accounts subject to disclosure. Thanks for listening. If any of you watching have any questions, please email them to me and I will consider it for a future segment of A Few Minutes with a Public Agency Attorney. We're adjourned until next month.